Welcome to the Disability Approval Path.
Welcome to Social Security and Disability, the Approval Path, presented by Spector and Lens PC. Since 1981, the team at Spector and Lens has helped individuals and families navigate complex Social Security and SSI claims, including hearings and federal court appeals. The firm focuses on securing benefits for people facing serious medical conditions, injuries, and long-term limitations. I'm Evan Mack, and today's episode focuses on vocational issues and disability cases, and we're joined by certified rehabilitation counselor Susan Entenberg. Susan works on complex disability matters involving job classification, transferable skills, and the way work requirements are evaluated in Social Security claims. So Susan, my dear, welcome. How are you?
I am well. How are you?
I'm swell. I'm swell. So Susan, to start, like right off the bat, like what is the role of a certified rehabilitation counselor in the Social Security disability cases?
Okay, so just to explain, certified rehabilitation counselors are individuals who work with people with impairments in relation to attempting to find a plan for them or or a goal for a return or a start to some type of work, gainful employment. So we have to look at an individual from various aspects to help them determine what they do. In Social Security disability cases, we're there as advisors, so to speak, in a disability hearing to help the adjudicator understand the work history of an individual and how it affects their ability to work. That's basically what that is.
So when you review someone's work history, what details matter most in understanding what the job is actually required?
Well, in Social Security disability hearings, we are provided with information as to the individual's education, age, and their work history. So we review that work history. We don't have prior knowledge of the individual. We're there as independent consultants and what we call vocational experts in a hearing. And we are there to identify what we call the relevant work history. In this case, it would go back, or in all cases now, it goes back 5 years that we look at the work history so we can identify what the jobs were, the duties and responsibilities of that job as they performed it, and what we call the exertional levels of that job. Were they sitting, standing, doing heavy lifting, things like that?
How does the Dictionary of Occupational Titles come into play when evaluating past work?
Okay, so the Dictionary of Occupational Titles is a reference source that was developed by the U.S. Department of Labor many, many years ago. And there is approximately slightly over 18,000 occupations listed in that resource. And it provides the names of the occupations, the description of the occupation in terms of duties and responsibilities, and then goes into more depth in terms of physical requirements of that job, educational requirements of the job, mental requirements, all of that. And we have to rely on the Dictionary of Occupational Titles to determine what we call skill and exertional level of the occupation that we're going to be talking about, the work history. So the DOT is very important in the role during a Social Security hearing.
So, Ms. Susan, sometimes a person's job includes duties from, multiple occupations. What makes a job, a composite job, and why does that even matter?
Okay. So just to clarify, pretty much in all jobs these days, we don't do just one thing and nothing else.
Right.
There's always aspects that you're going to be doing here and there, but it's part of that job. But there are times when the what we call claimant is performing two or more, usually it's two or so, individual tasks. So we look at two different occupational levels. I'll give you a couple examples. For example, if you're working, and we've had a number of this, a convenience store clerk, at a gas station or in a, grocery store or something like that, retail. your job primarily is a cashier. But another part of the job that you are required to do, it's a requirement, not just something you say, well, I'll just run and go help somebody, is doing stocking, the inventory, doing that sort of thing. So that would be considered a composite job, a cashier and a stocker. Another example would be where I've had several. You have someone who's a construction supervisor.
Right.
And they're doing a lot of the paperwork and a lot of the budgeting and estimating and things like that. But they're also, depending on the situation, required to help with getting the materials to the site, unloading the trucks, helping the workers, etc. So that's another example of a composite. You've got the construction supervisor, but you've also got what we would call a material handler. So those are composite types of jobs. And what makes it important is when we have a composite job, and one is considered a light exertion, one is considered a heavy exertion. The claimant in their testimony or in their form said they did it at medium or heavy, let's say either one, because they were the ones that it's specific to them. What we have to do is rely on what their exertional level was as to be the appropriate thing. So that's the difference when we're looking at how we identify what the jobs are.
How can the classification of past work affect whether someone is considered able to return to that job, Susan?
The way that we look at it is, okay, so say we have someone who is we'll just use cashier as an example. And that's considered in the Dictionary of Occupational Titles to be a light job. The adjudicator gives me a hypothetical question in terms of assume an individual of the age, education, and work experience, and they gives me certain limitations. And one of the limitations is they can do light work. So my response would be they could return to a light cashier job.
Right.
If they say they can only do what we call sedentary work, then they would not be able to do that job. And there's also a relationship between just the job itself and the exertion and skill levels, and age is very important in Social Security cases. The ages of 50 are significant, 55, and then 60 and above. So if you are above the age of 50, for example, and you are limited by the adjudicator to sedentary work, and you've never done sedentary work or you don't have skills that would transfer to sedentary work, you would be found disabled. Whereas if you're under 50, then we can say, well, here's some jobs they could do. So age is a very important factor. And obviously, as you get older, 55, if you cannot, light work is sort of the cutoff. And then when you hit 60, it's, not that hard to be able to get, it becomes a little easier.
What role do transferable skills play in determining whether someone can do, other work?
Transferable skills is that what we were talking about. Yeah. And transferable skills kick in when we're talking about an individual who is 50 or over. So if you are under 50 and the judge, the adjudicator, it determines that we're looking at unskilled jobs. If you have no transferable skills that can be utilized, I'll give you an example. You are a receptionist, and that's the job you did when you were working. The person is under 50, say she's 30, and they give restrictions and say they can only do sedentary work. And reality is that's a sedentary job. So they could do that job. Transferable skill is a skill that one obtains from an occupation or from your education that you can utilize in other types of occupations. There are jobs where a construction laborer, it's considered to be what we call a semi-skilled job, but there are no real transferable skills to at the sedentary level. So if the adjudicator says, we've got this guy who is 53 years old, was a construction laborer doing heavy work, and is now limited to sedentary work.
Right.
Are there transferable skills that that person has from that occupation that they can utilize in sedentary jobs? And my answer would be no. And at that point, at that age, they would be considered generally disabled.
So how do you evaluate whether jobs identified in the disability case realistically exist, in the national economy?
That's an interesting point. You have to realize that the Dictionary of Occupational Titles is an older reference source. And some of the jobs as they describe them in we call it the DOT, really don't exist the way we see them now. You have jobs where, you never used, you weren't using a computer, and now that's all you do on a particular job. So it changes. So you have to have an understanding, and that's why it's important that individuals who are being consultants in a Social Security hearing have an ongoing understanding of the labor market and how jobs are done now, and is there a need for those types of jobs, or have they diminished, or have they increased? So we utilize various sources to look to see if these jobs continue to exist in significant numbers. And there's software programs that we use that are based on Bureau of Labor Statistics that gives information as to the numbers of those occupations that exist in the national economy. One of the things that is looked at in Social Security hearings is not necessarily you would be able to find a job. That is not the issue. It's could you perform the job? So the market may be down in terms of job openings, but if jobs exist, that is the issue. So we can gather information in terms of numbers of jobs and how they're done now through various sources that we use in terms of software programs, the Dictionary of Occupational Titles. I do a lot of work with individuals outside of Social Security in terms of trying to help them with job opportunities. And we use things like the Occupational Outlook Handbook, things like that. Those are not necessarily used in Social Security disability hearings. It's very specific.
Where do workplace accommodations fit into the analysis of whether someone can work?
That's another issue where when I'm working with individuals not involved in Social Security cases, trying to help them obtain new employment, we look to see if accommodations can be made for individuals in a workplace setting so that they would be able to do a job. There's all kinds of accommodations out there that, employers may help with, providing to an individual who has some type of an impairment. In Social Security hearings, when we're asked, for example, the individual would need a walker or a wheelchair in a work setting. And my response would be, and you're looking at someone, like in an office setting and stuff like that. And my response would be, when you have things like a wheelchair, you have to be able to accommodate that.
Mm, mm,
And with, wider aisles, making sure there's ramps as opposed to things like that. And if you need accommodation, another example would be an individual has cognitive issues or mental impairments, and they need continual refocusing and things like that, or help with a job coach or something. That's an accommodation. That you cannot. Accommodation is not something that they would. If you need accommodation, you would not you would not be able to work in a Social Security disability hearing, which out in the world, in the market, there's accommodation that we try to get for people. But that, if you need accommodation, then generally you would be considered unable to work.
To kind of close things out, what tends to make vocational issues particularly important in more complex disability cases?
Yeah, I mean, a lot of times many times we have cases with both physical and mental impairments. The combination of both of those together make things more difficult. You may have to have someone who needs, very simple types of jobs, that sort of thing. And the vocational issues are important because you need to be able to establish what are the parameters that they need to work under. And if it cannot be, for example, they have a lot of issues with treatment and needs to go to the doctor all the time, or is off getting various procedures. That's an issue of absenteeism. Another example would be an inability to focus for periods of time. And that's where we come in with establishing what are the sort of criteria that employers will tolerate for that sort of thing. So we're asked those questions a lot about, say, the individual can't focus is off task for 20% of the time. Well, it's the vocational expert is there to say whether, in their opinion, that individual could work or not. Those become the more complex types of cases that we look at. The combination of various impairments, how it affects them, that sort of thing.
This stuff, Miss Susan. Thank you for your time.
Well, thank you. Thank you. I hope it was. I
Listen,
hope it made sense.
it was informative. I was riveted. I was on the edge of my seat.
Well, that's what we want. Well, thank you so much for having me.
Thank you.
And I hope to do it again someday.
Absolutely. Absolutely. This has been Social Security and Disability, the approval path presented by Spector and Lens PC. The firm provides compassionate, experienced representation for individuals seeking Social Security disability and supplemental security income benefits, including complex cases and federal court appeals. To learn more about Spector and Lens, visit spectorandlens.com. Thanks for listening, and be sure to like, subscribe to the show, and leave a review if you found this episode helpful. Thank you so much, and we'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.